think Judge Hurst's language in that type of situation was particularly applicable. It wasn't the obligation of the fire district to go through their open session minutes and find that it was responsive. It was to provide him the documents over the period that were responsive to his request. Now, that won't apply to every situation. The open session minutes is probably the quintessential type of situation where it would apply. But going forward, it's something to keep that in the back of your minds.
Once we have determined that we have a public records request, you guys hear me back there? What happens next? In order to help us figure out what happens next, the Access to Public Records Act has quite a few procedural provisions, and these are actually the most straightforward part of the Public Records Act. However, in 2010 so far, we've issued 12 violations, and out of these 12 violations, 10 of them contain procedural violations. As part of a way to protect public bodies from gaining these violations and the public from having to come to our office, the Public Records Act requires that each public body shall establish procedures regarding access to public records. However, no written request must be required if the record should be available pursuant to the Administrative Procedures Act or prepared for or readily available to the public. You'll see on your screen that we issued the Gwynn case in 2009. The complainant in this case alleged that a written request could not be required for this document because he wanted a list of a stimulus project. He said that the stimulus project list was already prepared and was on the computer and therefore readily available. In concluding that the town in fact could require a written request for this request, we examined that statute and determined that this document did not fall underneath the APA, it was not prepared for the public, and that there was no language in the Access to Public Records Act that suggested that computer-generated documents, whether or not they can easily be accessed, constituted readily available for this section. A new issue that we came upon this year came to us by way of the Secretary of State's office, who wanted to know if they needed to follow the APA when promulgating their Procedures for Public Records Act. Our department, in examining the laws, concluded that because the Secretary of State's office was in fact an agency, that it needed to follow the Administrative Procedures Act and it needed to follow APA as the other state agencies would need to do that. So the bottom line is, from this point out, state agencies, when they're promulgating their Access to Public Record Act procedures, need to do it underneath the APA. However, bodies that are not state agencies do not need to follow the APA. Some of the other issues that come up in conjunction with procedures of a public body are how and when a request is made. And promulgating procedures protects public bodies when it comes to this. In the case that was on the slide in front of you, it was the North Kingston School Department. The school department had found that they were having a lot of trouble because they were getting a lot of requests that were sent to them by emails. Frequently, these emails are going to people that had nothing to do with who the requested documents was for, and sometimes the emails weren't even getting to them. So they went ahead and promulgated a procedure saying that all requests needed to be in a written format, and they all needed to be presented to the superintendent of schools. When they did that, that ensured them against requests going to the wrong person or perhaps getting lost, because their proper procedure ensured that it could only come to a proper person on a written document. I wanted to contrast this against another complaint that we got in our office, where the public body alleged that they had not violated the Public Records Act by not responding within the 10 days because they said that the request had gone to the wrong person. The person it had gone to was the part-time town treasurer, as opposed to the custodian of records. However, this procedure had not been written down and had not been communicated to the public, which is something else you'll see on the slide. If a public body has a procedure, they must in fact communicate it to the public in some manner so the public knows what procedures they need to follow.
We've talked about this at prior open government summits, and it's still one of the most problematic provisions of the Access to Public Records Act. In the bound book, the actual provision 38-2-7 is at the top of page 13 of the bound book. After you receive a public record request, one of these three things has to happen within 10 business days. I know this is probably the one slide that we repeat every Open Government Summit, but year after year, when we look at our findings, it continues to be collectively the most violated provision. It would seem also to be one of the more straightforward provisions. We really can't say it more clear than after you receive a public record request, one of these three things has to be done within 10 business days. You either have to provide access to the records within 10 business days, extend the time period for quote-unquote good cause an additional 20 business days, so it would be a collective 30 business days, or denying access to the records within 10 business days. Some of the examples and some of the reasons we've got for not responding within 10 business days have been, yeah, we got the public record request, but we don't have the documents, or we would have to compile the documents, and the documents are exempt. For all of those reasons, we have found violations for. If you don't have the documents, or if they're exempt, or you would have to compile them, those may all be reasons not to provide access, but you still have to provide a written denial. We had a case, just to kind of give you how extreme the facts can get. We had a case, actually the North Providence case that's cited here, where a request was made for access to public records right during the March flood. Obviously that was a point in time where the town of North Providence and other communities were dealing with a lot of issues. But the town got a request. I think the request may have been actually made one day before the rainstorm. But the town didn't respond within 10 business days. What we said was the proper avenue would have been for the town to have extended the time for quote-unquote good cause. I'm not sure that there would have been an argument about the good cause in that type of situation given those facts. But again, the town didn't do that, so we found that they had violated the act for not responding within 10 business days. Another type of situation that we see starting to come up a lot is, particularly with people who may be making a lot of requests, cities and towns and public bodies are having some sort of informal relationship where they may just, either provide access or deny access, or somebody may come up to make an oral request for access to public records and they make an oral denial. Those types of situations, sometimes they work out, but when we end up getting a complaint, we end up finding violations. It's going to be based on the evidence that we have. If there's an agreement to extend the time and provide access after the 10 business days, do it according to the act. You'll save yourself some headaches later on. You see here, if records are going to be denied, what must be done, the denial has to be in writing. This is coming into play, particularly where an oral request has been made. The Public Record Act doesn't bar oral requests for access to public records. If you have procedures promulgated, and we'll talk about that later, that may address it. But short of that, a request can be made for records orally. And in some cases, an oral request has been made, and somebody will deny access orally. That violates the Access to Public Records Act. The denial has to be done in writing. You have to state the specific reasons for the denial and indicate the procedure for an appeal, which is set forth in General Laws 38-2-8. Due to the fact that there was a Rhode Island Supreme Court case this year, it was last month, Downey versus Governor Carcieri, as well as many others. And I don't know that this case really said any new grounds, but I guess it affirmed what the procedure has been in the past. In your denial letter, a person who is denied access to records has the ability to either file an appeal with the chief administrative officer of that public body, they can file a complaint with the attorney general, or they can file a complaint with Superior Court. Those are the procedures set forth in 38-2-8. What the Rhode Island Supreme Court made clear in the Downey case is that a person does not have to exhaust their administrative remedies. They can go right to court. Downey was a case where there was no appeal filed, there was no complaint filed with the AG's office. They went right to Superior Court, and the Supreme Court made clear that one does not have to exhaust their administrative remedies. And state the specific reason for the denial. We'll talk about that right now.